information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me?
Right out the gate, the defense is trying to downplay danger to the public. But pay attention, this isn't just about one incident. The judge is about to bring up a pattern that could completely change the outcome. Watch how quickly this argument begins to fall apart.
That with all, this is legitimately 4 and 5, with another one pending in Wayne County, and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, Assistant Public Defender Benzodiazepines on behalf of Mr. Barnhard, who stands to my right. Would you state your name for the record, please?
Philip Barnhard.
What are we doing?
Your Honor, Mr. Barnhard is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Is the court in receipt of the bond violation report from Community Corrections?
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and suboxone.
This is the critical legal moment. The defense is trying to argue technicality, saying the drug use might have happened before release. But the prosecution isn't buying it. Why? Because repeated offenses erase any presumption of accidental behavior. This is now about public safety, not timing.
I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check ex-jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument. But
can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those...
what?
Cocaine could stay in his system for up to a week if there's heavy use. So the failure...
Let's say...
Here's the turning point. The judge isn't just annoyed, he's signaling a legal standard. Risk to public safety outweighs individual liberty. Once a judge starts talking like this, bond revocation is almost inevitable.
Let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023, or 23. He's got a pending Wayne County one. He's got prior ones, and he's still using. So I don't know that he should be out, because at some point, luck's gonna run out.
Notice the defense's pivot. Since they can't deny drug use, they try to separate substance use from actual driving. This is a classic damage control strategy. If they can show no immediate danger, they might preserve bond. But will it work?
He's gonna get behind the wheel and he's gonna take somebody out. I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5, with another one pending in Wayne County, and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I would absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that, we don't know if this is a one-time slip-up, we don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having been...
This is devastating for the defense. When BAC levels are above 0.3, that's not casual drinking, that's near medical emergency territory. Legally, this shows habitual disregard for public safety. Judges do not take that lightly.
Having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I make that search into the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand it.
I just don't think the circumstances have changed since the bond was set because, and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate. At least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving a car. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. The court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving? All right. So at this point,
And there it is, the hammer drops. The judge doesn't just modify bond, he sends a message: freedom is a privilege, not a guarantee when public safety is at stake. This moment seals the tone for the rest of the case.
We'll do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. Sir, you're waiving your right to preliminary examination in these cases?
Sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution?
Sir.
People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
Sign the
It
form
might
to
have been
waive after
PRs,
the
and $25,000 PRs, but I
There, I have on each of these that they're PR.
oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive.
We do.
Preliminary examination having been waived, defendants bound over to circuit court on a single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with Judge Conlon.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded.
Okay.
Yes, you may. What was that date again?
24th, Your Honor.